Welcome back to another video. So friends, today in this video we are going to share with you an important concept of one of the important subject, that is administrative law. So today in this video we will see how the meaning, nature and scope of administrative law is evaluated and what are its nature, scope and its content. So first of all we will see evolution of administrative law as to how is its nature and scope are importance for us, and this is a very important one of the important subjects of LLB course. So firstly we see what is the general meaning of administrative law, because it is very difficult to define a very specific definition of administrative law, but here we will try to explain in a very easy language with the help of the jurists also as to what is the proper meaning of administrative law. So let's see the meaning of it. The administrative law is a branch of a public law which deals with its structures, powers and functions of the organs of administration, the limits of their powers and the methods by which their powers are controlled, including the legal remedies available against them. So it's a general meaning, but you can better it understand with the help of what the jurist had said. So if we see the definition of proper definition with the help of the jurists, so according to Professor Jennings, who is one of the very prominent jurists, had stated that the administrative law is the law relating to the administration. It's a very simple to state, but they had said it's a definition of a jurist. So it designates the organizations, powers and duties of administrative authorities. Secondly, according to Professor Wade, administrative law is the law relating to the control of the government power. Now we see these two definitions cover the four aspects of the administrative law. Now we see what are these four aspects. Firstly, it deals with the composition and the powers of administrative authorities. Secondly, it fixes the limits of the powers of such administrative authorities. And thirdly, it prescribes the procedure to be followed by these authorities in exercising such powers. And lastly and fourthly aspects is it controls these administrative authorities through judicial and other means like other judicial powers. So although various attempts have also been made by the different jurists to define the definition or meaning of administrative law, its natures, its scope and its contents, but as of now none is right or wrong in absolute sense. In fact, it is not possible to evolve a proper or comprehensive precise or satisfactory definition of administrative law so as to demarcate clearly its nature, scope and its contents. So now we see what are the nature and scope in general meaning of administrative law. So according to Professor Freund, the main problem of administrative law relates to the nature and operation of the official powers, the formal procedural conditions for the exercise of powers, official and communal liability, the specific remedies for the judicial control of administrative action like legal, equitable and statutory judicial limitations of powers and questions of administrative finality. Now we can say that the administrative law can precisely be said to be a study of multifarious powers of administrative authorities and their control. The nature of powers exercisably by the administrative authorities can be studied under the mainly three heads. Now what are these three heads? The first one is legislative or rule making. We can also say it like a rule making power. These three heads I will share with you in a separate videos, because very important, one of the important topics of the administrative law. Second main head is judicial or adjudicative, and the third main important head is purely executive power of a legislative. So now actually if we see, the administrative law is mainly concerned with the control over the exercise of the powers by the administrative authorities. Professor Wade has also rightly observed that the organization, the methods, the powers and the control by the judicial authority of all public authority is the ambit of administrative law in UK. It is also to be noted that the scope of administrative law in India is very much similar to that of the United States. In fact, the problems before us, that means to say before India, is to prevent the potential threat to justice and encroachment on our freedom. Administrative law comprehensively deals with the ways and means to keep the multifarious powers of administrative authorities under its control, and it also intends to prevent the growth of an autocratic rule by administrative authorities. It provides for the safeguards to against what Lord Haworth has observed. Now they described it as a new despotism. Now conclusively we can say what we has discussed today. We can say that the administrative law is primarily concerned with the judicial control of administrative powers. This is the crux of these videos. The rules of judicial control are generally derived from some basic principles of constitutional law, rule of law, and the principles of natural justice. Now, in short, and in a nutshell, we can say that the administrative law mainly deals with 5, 6, 7 some factors. Like, firstly, we can say how it deals is the existence of various administrative bodies such as wage board, like Central Board of Revenue, Commission of Inquiry and Advisory Boards, tariff commissions, etc., or their organizations and powers. Second, rule making powers of administrative agencies like delegated legislations, safeguards against abuse of powers by the judicial control, judicial functions such as of judicial functions of administrative agencies like administrative tribunals. We can say CAT, Central Administrative Tribunals, also work as the for safeguards like the administrative powers. Next is remedies like writs, injunctions, etc., or other procedural guarantees like rules of natural justice, principle of natural justice. Government liability in tort and contract, and or this is applicable in public corporations also, because this is a legislative powers. Like tribunal has also been constituted for the grievances of the general public, for public corporation. So this, what is the purpose for function of organization of the tribunal for like this, we will share or discuss in another separate video. So today our motive is only to basically share with the basic meaning how the term administrative law is evaluated, what are its meaning, nature and its scope and content. So friends, I hope you like the basic information about it. We will also share separate videos or other topic like delegated legislations, rule making powers, or we will share other important aspects on the subject of administrative law, which will be helpful for you in your LLB examination or entrance examination. In case of any query, you may contact me either through my Instagram or Facebook, or you can also comment in the chat box so that I will give you the response to your queries as soon as possible. So friends, kindly share the video, like it, subscribe it, and don't forget to watch our other videos which are prepared on the same topics in our playlist. Thanks for watching this video.